And this hopefully will lead to first time creating a death penalty advocacy center in India. That's what we started with a hope, I think, when. And Anup is very modest in not admitting, but also Anup indirectly contributed to the changing progressive jurisprudence in the Indian Supreme Court, indirectly, in the death penalty jurisprudence, where the Indian Supreme Court is moving towards the progressive abolition of death penalty in the two landmark cases. Indirectly, I think he contributed into this. One is where the delay in the deciding of the mercy petition was a ground for moving from death penalty to life imprisonment. Second is now recently the Indian Supreme Court also has taken a stand that in all the death penalty cases, particularly when it comes to the Supreme Court, there should be open hearing. So I think that's where we look forward to your critique, comments, observations. How do we take it forward? This the whole area of work as of now, NLU degree is being still working in 20 states. How, as a criminologist, criminal law teacher, and a human rights activist, how do we take it forward and carrying forward this work in future? Mrinal's sentencing on rape is, I think, is a very interesting study, because taking from, he has explained about what are the three factors which are primarily responsible for impacting the sentencing on rape, and he explained, and through his research also, he explained about, demonstrated how the myths of rape and stereotypes still dominate. There's a whole patriarchal bias and notions within the judiciary. In fact, if I remember, I think Mrinal also may be part of that discussion with the, in the initial days in the NLSIU Bangalore, with the British Council has, I think, facilitated that discussion on is a exchange between the judges and the academics and researchers. If I remember that day, we asked in that exercise the judges, think about, tell us who is sitting besides you, share your recent sexual experience. This was a real 2 days workshop with the judges in the NLSIU Bangalore. Judges were sitting. We asked, if you are sitting, who is your next person? Share your recent sexual experience. Everybody was shocked. That's what we said. This is what you are asking in the court. How the complete, how the trauma, victim, and everybody. So this is a very revealing, I think, here also. That's what Professor Pandey was trying to make in the beginning. Core areas of research in criminal law, criminology, these are all still contemporary relevance in the Indian context. We are not saying that the other, private security and others, are also areas which we may have to look at and re-examine. Third, Sugandhi is very interesting, that comes out of the field work in the access to legal aid and others, the micro study. We also have two research projects currently my colleagues are doing. We have a prison legal services clinic. My colleague Bharti is coordinating this for the last 2 years. We have this is an exclusive compulsory mandatory course as part of for the final years. Students will visit, they will look at how the access to legal services can be provided. We go with a questionnaire. There are two main prisons here. One is Tihar, largest prison in India, maybe in South Asia, and then the Rohini prison. We go with the students, we go with a questionnaire, and same impression we got, like Sugandhi has explained. None of them have met their legal aid lawyer. The quality of legal aid is doubtful. Nobody comes and meets them, so we have taken their cases. We went back to the court, and the students, with the help of the faculty, have moved the applications for release of the bail. But my last, I think, comment and observation is somewhere we need to look at criminal law. Criminology is not devoid of established principles of due process and human rights principles, whether at the national level, international level. Somewhere there's a dilution of the standards in policy, research and implementation. After the war and terror, there's a dilution of the standards. I think the contemporary legal research, criminal law research and criminology research should look at, once again, how do we bring back the human rights and human sensitivity into the research. And sometimes this is important where issues of injustice has almost all perpetrated into the criminal justice system. So these are, I thought I just briefly will share. Maybe tomorrow I will have more time to discuss about some of these issues. Thank you.
I think I will make a brief intervention here. I'm happy that we're moving towards the core. We had periphery and we are moving towards the core. But we have to define the core. Wrongness or miscarriage has got to be operationalized from the point of view of empirical research. And when I see these three presentations, by Mrinal's presentation is on wrongness gauged through the secondary source. Judge's sentencing function is judge is applying his mind, and the wrongness is gauged through a secondary source. But Anup and Sugandha's presentation is wrongness judged through primary source. The interviewer or the person who goes to the spot, he is seeing as to how a death row prisoner suffers more than any other prisoner, because at the end of the tunnel he is awaiting death. Nearer the end of the tunnel, greater his nervousness. If this could be a kind of study, depending upon whether he is being convicted by the trial court, given death sentence, whether he is, how does this anxiety factor, if it could be psychological and all that, empirical study of death row people across the country or in one state from prisons, that could be an excellent area of research that could be done. Empirical. Farther from the end of the tunnel, lesser anxiety, and nearer to the end of the tunnel, greater anxiety and greater sort of submission to indiscretion of the prison authorities. This could be one. The other could be, in just case of Sugandha, again a field research. You go to the field, the insight changes, the whole perspective changes. And that research, empirical research done on prisoners, whether they are getting legal services, whether they are getting legal aid, whether their conditions are being monitored or not, conditions in prison all over. And if this kind of, you have standard minimum rules and they are grossly violating most of the prisons, excepting some prisons like Bihar and all, they are grossly violating. So, research, field-oriented research. Secondary source research also is all right, because we have to explore the wrongness of criminal justice system. You can identify many areas, because the wrongness or miscarriage of criminal justice system is still underexplored and theoretically underexplored, and empirically it is almost unexplored. I have seen on death penalty a lot of writings, but none like Anoop's team that has gone into empirically the field of death penalty. Similarly, those who have done work in the prison, once they are there on the spot, first hand, primary source information, empiricism based on primary source information, becomes a different kind of empiricism. And that has to be sort of, to my mind, is what is required in the core wrongness areas, in the core miscarriage areas of criminal justice system. And I think with that I will stop.
Anything you want to make? Right, okay. Right, the floor is open.
I had a question for Sigena, just at a point of application. This is probably really obvious to most people in the room, but you mentioned on one of your slides that there was 1.3 arrests per case. So that suggests to me there's a very different meaning of case here to what it is in the United Kingdom, where a case is open before there's been arrested. So that the 1.3 per case suggests every case results in arrest.
I guess they've just taken out an average, so it says 1.3.
So when is the case opened though? So is the case opened by the police while they're doing the investigation, or is it opened once they've actually made an arrest?
No, when they've made it.
Right. Yes, that's what I thought.
Let me ask you, when does the case get opened? So I think let me just add to that. So I think what you are talking about, once the registration of the FIR and so we have a situation where once you report the crime, that case is opened in the police record. Then you complete the investigation, and I think that's what you're talking about in the UK, that you complete the investigation and file what's called a charge sheet. That's a police report, and that's when the case is opened technically in the court, though in that meantime the person is being produced before the magistrate multiple times, but the case technically in court is not opened until the charge sheet is filed. So I think where the 1.3 per case would be at the stage of FIR.
Yeah.
So I was thinking the Indian police are incredibly efficient.
So when they mentioned about a case, DK Basu case, which is a very landmark case in 1997. Before that, in 1996, there was a case, in fact, which was borrowed the principle from UK Police and Criminal Evidence Act and brought the principle of custodial memo for the first time into the Indian jurisprudence. That was further strengthened. That's a 1996 first case where the then Chief Justice of India, he said in all cases of arrest, there is no proper documentation. How do you document? He said in the UK you have a Police and Criminal Evidence Act, you have a custody memo which is issued, there is a custody officer, there is a regular review of the arrest and detention. He said this is what is required. This will prevent illegal and unlawful arrest. And that in 1996 was further strengthened in 97 in the DK Basu case. So that's the principle which they have borrowed, at least to some extent. Custody memo for the first time is introduced into the Indian jurisprudence so that they can go to the court, they can challenge the illegal arrest, they can file a criminal prosecution, they can file for a compensation.
Yes. I'm not sure that it's not a panel, a question to the whole panel rather than just one person in particular, because it seems to me that all three presentations spoke to the same issues of unequal justice, in particular barriers to access to justice for people held in prison, but also in drawing on your paper, unequal justice in terms of some victims being more deserving than others. So a sort of hierarchy of victim status as well as a sort of hierarchy of disadvantage within prison or within the population is subject to hidden powers. And I suppose the question, if there is one, rather than just a comment on the commonality there, is to really try to think about to what extent should we expect or hope that criminal justice processes in India or elsewhere can really do anything to bring about social justice, given that we're talking about populations that when they went here, and certainly Anna's presentation was very clear, were people at a very poor socioeconomic disadvantage. So you have a certain population being the police more likely to be subject to miscarriage of justice or likely to enter prison regardless of whether they're actually guilty or not. And then a system that doesn't really do anything about that or doesn't attempt in very real ways, doesn't provide legal aid adequately, or the legal aid lawyers don't behave in the way that one would hope that they would. And despite the protections that were in place that we spoke about at the end, they're clearly not doing their job properly, regardless of the best intentions. And in a sense, you could respond to that by saying, you have an unequal society. These people are going to end up in prison, and these people are going to have the worst time of it when they're in prison. So what hope can there be for any sort of movement towards using criminal justice process to try and bring about more social justice? I suppose that's quite a long
At least in the death penalty context, the way that plays out is that argument is not acknowledged. That it is to say that you can tweak the administration of the death penalty in this country, be it by the delay in deciding mercy petitions or saying that the Supreme Court will hear all review cases. That's just, and I completely agree with you, that none of that is actually going to change the structural problems that the death penalty faces, be it in the socioeconomic context or the access to justice. None of that is. But according to the system in the death penalty, it's like an older American debate that we can sort of tweak it till we make it, and the attempt is to make it fairer. And the thing is, everyone's problem is that death penalty is administered unfairly or is inconsistent. So the system's response then is, okay, we'll try and make it more consistent, we'll try and make it more fairer. But the argument from our end is that you will never end up having because of these systemic problems, you'll never end up having, at least unless there's socioeconomic transformation in that sense, you're not going to get those criminal justice outcomes. And until that point, you cannot rely on this system to impose death penalty.
I suppose that was I'll come back.
Yeah.
That was your point when you said at the beginning that because in India it's been so rarely because of the rarest rooms, then you end up with a situation where people say it's not really too much of a problem, it's just a person a year, for example.
Exactly.
So it goes off the radar because, sorry.
Yeah, just to respond to that, I think one of the big issues is access to justice. And I don't think criminal justice can actually bring about social change. It's not the role of the criminal justice system to bring about social change. But I think the one issue that you can see across all our presentations is that we have the structures. It's not that we don't have them, it's the way structures work for some people and don't work for some others. So you have all these people, the 75% of our population which are under trials, who a lot of them don't get out because they cannot afford bail. And then we introduce plea bargaining, and we say, okay, if you don't get bail, why don't you plea bargain instead? And then we celebrate the success of the plea bargaining regime, which basically is showing you that the entire system has failed from top to bottom if your person is pleading guilty because he's not got bail earlier. That's one. And in the context of offences against women, the entire problem was of accessing the legal system itself, be it filing a report, to invasive medical exams, to, like Professor Rao was saying, the manner in which court testimony is recorded, and then into the entire process, and the sentencing process looks as if you're sentencing the victim, not the offender. That's one. And then I think Justice Sikri in the morning mentioned as a victory of the Indian justice system being the Kasab case. I would completely disagree, because what he said is that we provided a lawyer, and that lawyer did an excellent job, and yet we know some of those people, they're excellent lawyers. But you provided them at the Supreme Court stage. At the trial court stage, when you let a confession be recorded without providing legal representation. The Supreme Court shuts its eyes to that, saying, no, that's fine. You know that because the role, as the Supreme Court said, is the role of a criminal lawyer, and especially a defense lawyer, comes in not at the stage to stop someone from confessing and stating the truth, but to ensure that he gets rights through the system, so that in the trial process his rights are protected. So therefore you have a system which is used differently for different people. And so I think the argument more here is how can we actually work towards ensuring that the system that already exists is workable, and it is. And I think I was discussing with Anirudh earlier. He said it was such a depressing session that the entire system has collapsed. There's nothing that can be done further. I don't think that's anything that we are talking
If I may
about.
just take that depressing sense a little forward, right? And in my own experience, you do come away with the feeling about the futility of the law, right? That the law is like the most irrelevant thing, that you could, as you say, we could make better structures, we could make better laws, but somehow you still get the sense that that's really not the problem, right? And maybe it points to that we need to appreciate the role of the other factors in sort of making the legal system completely ineffective.
One does, sorry, can I butt in? I'm going to see I've been prompted butting because you said I don't think the criminal justice system can bring about social change. Now there's a version of that claim that I can swallow, which is it's actually you might think it's sociologically unlikely that criminal justice systems are going to be at the forefront of social change. I think that's true. But there's a small and dangerous jump is possible to make from there to a kind of structural fatalism, which kind of extracts criminal justice from social justice politics entirely. Now that seems to me to be a mistake, and it's a mistake because to some extent social change, if it's ever going to happen, has to be mediated through institutions, and you can't have every institution turn around and say this is nothing to do with me. You know, the health sector, the education sector. So in some sense, it might be that some forms of social change you do want to be mediated through criminal justice, and part of our task is to work out what they might look like. And even if you don't accept that claim, there's a kind of negative version of that which says, well, the criminal justice system just can't stand innocent of the social and political inequalities that surround it and that generate, to some extent, generate the people who end up inside it.
But I suppose on that point, there would be, it's not really the law that's doing that work, it's the actors in the criminal justice process that are the ones that try and shift institutions along, and that's part of the cultural thing, not so much a structural legal framework. But you have to work within that. Yes.
No, I think, Caroline, you must keep in mind, law is not a panacea to social problems, economic problems, not at all. But certainly, given this law, if it is worked equally or fairly, if it is driven by motivated people, the judges, the policemen, the prosecutors, they can make a lot of difference. And the social activists, NGOs are doing wonderful work. This work of CHRI in Rajasthan prisons is a testimony to that, but there is a limit to it. You have to also think of ways of reforming the law with a view to accommodate better the marginalized, the impoverished, at the same time remove this economic impoverishment, minimum wages act, other things. There are other measures, but the law can also be simultaneously. There is no conflict between the two. In your society also these problems are basic problems. The whole critical studies movement, Stephen Box has been writing, and people have been writing, Albion's Fatal Tree, and all those, the activists in Warwick have been working, and so therefore this has been a endemic problem of capitalist systems in which even socialist systems, in which law is a part of the superstructure. Economy determines everything, and more economically driven society, as now we are becoming, and we are trying to do this impossible thing, because I have worked on access to justice programs, taken the students to the prison, taken the students to the courts, lowermost courts. And I know, I used to tell the students, this is not a solution. But at this time, you cannot sit and fold your hands and say, I will not do what little bit I can do. Therefore, this I have been able to give access to at least 10 people. That itself is, I'm not saying, I'm not holding that pretension that I will change the whole system. Nobody can change the whole system.
You want to come in?
What I wanted to say is, I think we need to bridge that gap between the theory and the practice part of it. You know, we have good laws, but I think the law in our country is much ahead of, you know, what is there on the ground, you know, on the ground reality. So we do not have means to implement the laws. We do not have proper infrastructure. We do not have proper staffing, and, you know, all sorts of problems. So the law, there's no problem with the law. I think it's though, yeah. I mean, there have been you know, debates on how the amendments have come about, which are mostly the emotional outbursts, you know, which have led to the criminal amendments. But then, keeping that aside, I think you know, there's a huge gap between what we have in the books and what is there in the so.
For me, I slightly differ from that. I mean, I think there's a problem in imagination also, how you view these problems, like access to justice. One of the major thrusts, and from my current work at the court, is that to solve this problem of appearance before magistrates or before the judges, the thrust is so much on technology, right? So if you go across prisons, you see this increasing trend of wanting to video conference out of the prison so that the hearing happens every time, right? But that is so decontextualized that visit to the court every time is the opportunity for the prisoner to meet the family, because the court, it's so difficult for the family to come to prison, wait an entire day, spend an entire day, and even then you get to meet, and you really have to go and see how futile what they call a meeting is. It's across basically a mesh, and there are about 50 people standing on both sides yelling, and nobody can hear anybody, and that's the only time, as we said, the prisoner gets to meet the lawyer. So now if you just want to keep the prisoner in jail and in prison and then video conference out of that, yes, it solves one problem, right? Oh, that you have the hearing, but you really, it's decontextualized. You're not really looking at what is there's so many benefits of this prisoner going to the court on a regular basis.
So this is, I think, a major challenge of science technology appropriating the criminal justice system. We need to use the science and technology for the betterment of the functioning efficiency of the criminal justice system, but the procedural, there is an amendment in the India, this every 15 days, remand where they amended. Earlier it used to be a physical production before the magistrate every 15 days, so that the court acts as a monitoring agency over the prison system. Now this is completely taken away by the video conferencing system. So this is a danger, even including the DNA fingerprinting system. All over the world, including UK and in the Indian context, there is a bill which is pending before the government of India. So DNA banks, data banks, research and others. And I was reading one research published in the British Journal of Criminology looking at the DNA fingerprinting research in UK. They said the research, one of the major findings is it now has an impact on the efficiency of the investigation department in the UK. They are thinking that the DNA will solve everything. There is no need for a policeman to do the basic investigatory work. So this is a real danger. I don't know how we have to think about a strategy for this.
Yeah, continuing to this one issue that the technology and other things we are talking about. You know, there is one more thing that the state-centric measures are also inclined to seek the cooperations of the stakeholders in various ways. It may be the prisoners, it may be the witnesses, it may be the litigants. And all the measures are directed to seek the cooperation for the convenience of the disposal of cases at times, or for the convenience of the fast-tracking the cases. In all those measures, the interests of the stakeholders are not premised, are prioritized. All the time, those measures are guided for the smooth run of the state machinery, rather than the interest of the stakeholder in the process. Like, for instance, he mentioned about technology. I mentioned about fast-track courts. Fast-track courts, in several places, justice cannot be put to fast-track. Like in India, we have the system of public courts, Lok Adalat. Thousands of cases are, fast-tracked in one day. Now, justice hurried is justice worried in several cases. So, what we have to look at, what is the ultimate intention of initiating these measures? Are they really going in the interest of the stakeholders who have the grievances with regard to certain issues or not? Or it is merely the fulfillment of the smoothness of the state machinery that the cases should be fast-tracked, the trial should take place in a faster way, or for that matter, the technology must have so that the deployment of constables in the premises of the prison is avoided. So lot many things are happening. And one more thing which is associated, that all these things in mainstream literature, when we are talking wrongness, they are also mentioning technical errors. So are they really errors? Or they are complete departure from the principles of the jurisprudence or criminal? They are mentioning error. Like, for instance, misidentification, forensic errors. I am talking about in the context of wrongfulness of the process. So they are using these are the errors. Now, these errors are deliberate, or these errors are inadvertent. So we have to fix somewhere accountability also, because at several places there is no accountability. And that's why the entire abuse of process is happening within a brazen way. That is the major issue. So like I sometimes feel the system wants to perpetuate certain kind of ideologies also. That's why these things are happening with significant freedoms, and they refuse to reform. Despite in India, I don't know, this is the subject of this. Despite such a, I would say, commission after commission after commission, judicial reform, police reform, the situation has not changed. Probably the system wants to run in a particular way. And the disjunct between academia, intelligentsia and the system has become so obvious. For that matter, in several countries, US and UK, they also say that the research inputs of the academia is not reaching to the system. Therefore, progressive processes and positive reforms are not really percolating down into the functioning of the machine.
Let's go back to the point about the death penalty. It actually touches on what's talking about. I think you mentioned that there are no death row equivalents in 8 states at the moment. Is that correct? Well, the immediate question then is why? Why is it not being used in those 8 states? Are they structurally different to the states it is being used in, or is it that just random chance? And the reason for bringing that up, obviously, there's been a lot of work done in international context looking at kind of socio and economic drivers of different criminal justice outcomes. So Wilkinson and Pickett's work, where they find that inequality correlates with everything, and one of the things that correlates with rates of violent crime. I could show you data from the UK that says that police activity is differentially distributed, etc., tackle that makes the same kind of points. And that work is kind of notoriously difficult to unpack what's going on. But India may be a good opportunity for doing some of that work because it is one country. So you're not bringing the kind of cross-country comparison element, which is the difficult bit. But that all collapses if it's just a random process, like this year.
And that's why it's good that we did all the states where there are death row prisons, because even amongst the states where there are death row prisons, there's such varied practice in terms of how many death prisoners are on death row in each of these states compared to their population, why it's high in certain states, why there are certain thing is there are certain prosecution practices are very different across states, and we see that. And death penalty versus, there are certain states that give death penalty for certain kinds of crimes, right? So that has helped us understand, even in taking our work forward in terms of if we were to have a preventive strategy on the death penalty, which kind of crimes attract death penalty in different states, right? And I don't think we have a good handle on why certain states have more death penalty cases than certain other cases, and why there are certain other states, and mostly the northeastern states, that don't have any prisoner on death row. And it will certainly be a fascinating path forward to understand this variation among states that have prisoners sentenced to death and states where there are no. And also be interesting to see how long they have not had prisoners sentenced to death.
Can I just clarify, because you said at the outset, this is, I'll start here from a low base, so bear with me. You said at the outset of your talk that the death penalty is a national penalty, but it seems to me it's a national penalty administered by states. So the charging and sentencing decisions are made at state level, is that right?
So investigation and charging are and the court structure is also state. The lower courts is in that sense state-based.
And is there,
but it's a national in that sense.
Right. And that's why it's a moot constitutional point whether a state could effectively opt out of the death penalty, even if none of us effect.
Yeah, none of us. Yeah. You wouldn't think.
It's a unitary system. I wouldn't say that the courts in the state are by the state, because the high courts of course have superintendents administratively, but judicially it's the center. So we don't really have that federal.
So if you went through if this individual state went through a long period of not using the death penalty without ever exclaiming that it stopped, so in other words, explicitly mounting a challenge, but just de facto stop using, would the Supreme Court?
No, but the state, what the state could do is not ask for the death penalty. Right? A state.
So there's a form of, as it were, stealth abolition that is open to states.
Yeah.
Right.
So a state, because the state has control over investigation and prosecution, and in that sense, the judicial being independent does really have a say in that.
And is it, to return to Ben's question, are there any states for which you could see evidence of any kind of stealth abolition strategy going on?
I must admit, it's not something we've looked into in terms of amongst the states that don't have that role. How long?
Which are the states?
It's mostly the northeast, and I think Orissa now has no that role.
That's not some, that probably is recent, because we do have cases from
Yeah, but that's what I'm saying. I don't know the.
Yeah.
I'm a bit more interested in the northeast.
One explanation that I don't know, this is hazarding a guess here, is you have the legitimacy of some of the offences depends on how each state looks at what the offences are and the underlying offences, like you said, for the prosecution to ask for the death penalty. So would that possibly explain that in a certain set of states, if you do not really agree with the underlying motive behind the offence, you might not, if you agree, you might not ask for the death penalty. Say, well, like you said, something like a property dispute in Haryana, for instance, might be a situation where the state asks for the death penalty because you're looking at land grabbing, and so you want to.
Do we have any? I mean, the other part of this picture might be if the death penalty is discretionary. Do you have any relevant data on what triggers charging decisions and sentencing decisions around the death penalty?
No.
And is that about seriousness of offence? Is that about caste and class?
It has to be the rarest of rare. So
I think as Vinal has said that as far as Supreme Court judgments are concerned, there's a very exhaustive study on the inconsistency of it. But as far as the trial courts are concerned, if you go through the judgments, it's very much like it's the tests that they use, and that's what one of the things I wanted to say was that the amount of incorrectness in application of law and precedent is mind-boggling in that kind of cases, right? Where the Supreme Court has specifically said you can't use this. You repeatedly see it being used in lower court cases and in high court cases. Like recently in a case where the Bombay High Court upheld death for a man who just took a bus from a bus depot and just went on a rampage in Pune and killed about 9 people, right? And there the court has always been clear that this collective conscience argument in giving death is irrelevant. Now here, and this is just like last month, the court is saying, it's such a gruesome crime that you committed that you've shocked the conscience.
One more thing regarding this state-based analysis, I think you can also look at the total number of capital offences, rate of total number of capital offences in those states which are eligible, which could be eligible for the death penalty. I think if you see in that ratio, probably you can reach to some conclusion because northeast states are not so much prone for capital offences. So naturally the execution things or cases are bound to be lesser. Similarly in case of Odisha also. So it is the rate of capital offences in a particular state which could be in proportion to the execution. Is there any state which is having highest number of capital offences but lower number of execution rate? Now this can be a very interesting analysis.
But whatever, my sort of worry with that is that the counter in terms of how many cases could you have given death that you have not given death, right? But so how would we get around the problem that it is not mandated? In that sense, I don't have to give death.
Exactly.
So
it is very
the challenge would be to develop that model in which you could have given death in a 302 in a murder case. In some cases, just for murdering one person, you are given death because of whatever factors they think are relevant, and they say, okay, no, that's including things like
bare look in which the capital punishment is possible.
Yes.
Bare look at those cases and their number in those states can give some hint.
A clearer picture.
No, but I think the subjective satisfaction of the judge, particularly the High Court judge, confirming the death sentence. I know Justice Horbet Suresh of Bombay High Court. He said in 78 cases that came for confirmation before him, he didn't confirm death sentence even in one case. That is what he claimed, and he was very proud
bench
of that.
specific.
So it is the judge specific also.
Yeah, and Justice Bhagwati has never given any death penalty.
With the pre-independence, I think historical research on death penalty, maybe Amnesty International document cites about this. They said before the independence there is a state of Travancore. Now it's called a state of Kerala.
That is in 1958. That study is 58 custody, yes. That was used by Justice Krishna here.
Yeah, exactly.
Dalbir Singh's case.
Yeah, this study says for 3 years the state of Travancore has abolished death penalty and studied the crime rate, and they introduced again and they studied and they said that there is no increase in the crime rate. This is one. Second, historical research people quoted about Nizam state. Nizam state is now the current Hyderabad or Andhra Pradesh or Telangana state. This is the Nizam state. Nizam has a moral ethical concern. He said during the Nizam state there is no awarding of death penalty. The entire Nizam state, maybe about 200 years or 300 years in Hyderabad and other areas, there was no death penalty was given. So the government was committed. They said that no death penalty. So these are all the historical research. I don't know how far it is.
I think a couple of points. Going through that, the Supreme Court itself 5 years back has spoken about how the death penalty is very judge-centric, and I think research does show that, I've done some of this work myself, that the underlying offense is very important, and that if in one state something like killing your family for property is considered a huge thing, so the prosecutor will definitely ask for death penalty, judges more than likely to impose that. In some other state, the issue might be something else. So I think the underlying offense because of which the person has committed, ended up killing the person, is a very relevant factor. And like Anup mentioned earlier, something like rape and murder, you will definitely get the death sentence in most cases.
Just because it's a minor.
Especially if it's a minor, yeah, it's 100%. Right. So it then also gets to what is the underlying offense. Why did you actually commit the murder. In that context, the case that you mentioned where someone threatens, where a man threatens to kill the family, that becomes the aggravating factor in, the rape becomes the aggravating factor in giving him the death penalty, not really the 5 people, because there are other cases where someone has killed 5 people and got life imprisonment. So,
I think what we're finding is there could be further localization of the context in that sense of in that village who did you murder? What are the caste relations? Right? And like in Bihar, for example, caste massacres up until about a decade, half a decade back were rampant. Like the upper castes had a sort of private army that would go and massacre the Dalits with sort of scheduled castes. And then the sort of more Naxal movement through which all the scheduled castes were sort of attracted to and were part of would then retaliate or I don't want to say which ones initiated it, and they would retaliate and massacre the upper caste. Now what happened in these cases was when the upper caste were the accused for massacring Dalits, scheduled castes, caste was a huge issue in Bihar, continues to be an issue in Bihar. They were prosecuted under the normal Indian penal code. Whereas when it was the Naxals who were sort of being prosecuted for massacring upper caste, you saw the anti-terror law being, the TADA being used against them. Now that is very crucial because when the moment you're charged under TADA and it's the kind of criminal justice protections are diluted massively. Right? And so you see, so now you have a case where the only people from Bihar on death row for caste massacres are 5 Dalits. And so this local content of caste, economic structures, and and we have to account for that local context.
In UK, you don't have death penalty on the statute.
No.
Not even after this terrorism act.
There's a question at the back.
I just had a question to Dr. Abu. In terms of, do you think, I'm sure that there is scope for carving out independent research on lapses in police, on policing and police investigation, which has come out of your work, and if you've thought about that, how you could, start small and then maybe get
and I think part of this we're doing 2 reports for CHRI on the practices in Rajasthan and West Bengal. And I think we see common practices across states on this. And and especially in rape and murder cases, it is about, there's very little use of scientific evidence in that sense. There's very little, even where DNA material is available, they do not rely on it, right?
Contamination of crime scenes, protection of evidence, just the most basic, all of that is a huge factor.
There's one case from Kerala, and I was talking about the other day also, Anthony's, and again Anthony's Supreme Court's confirmed governor has rejected, waiting for the president to decide his mercy petition. Anthony had murdered, or is convicted of murdering 7 members of a family, and he was said to have an affair with one of the women in the family. When the Kerala police, as a local state police, were investigating the case, they had said that they had found semen in the woman, and that was the basis for initially arresting Anthony. Though the analysis was not done at the point when they arrested Anthony. But when they did the analysis, his claim is that they found that the semen was not his. And then the case is taken over by a central investigating agency, that's called the Central Bureau of Investigation. And in the entire trial, and in the case record, there is no mention of semen ever having been found. Right? Now, we are coming into it after 10 years, 15 years after the case. Now you can't find the sample. Right? You don't know, there is nothing to tell us if the Kerala police really found semen, because it was tested, and where is it sampled, right? So, in that sense, a sort of an innocence project here faces massive hurdles in terms of the sort of collection of evidence, how the evidence is not stored properly, and you really can't go back to, there's nothing to really go back to.
Just one item, on a small point, have all the 7 northeastern states established an independent prosecution? Or is it still, I think that was maybe that they.
We may not have a presence also, I think maybe except,
And shortage of
Guwahati.
judicial magistrates may also be there. Some of these things.
And I must, all terror cases under terror legislations are either against only Dalits, scheduled caste, or Muslims.
Are there any women prisoners who can?
I think we've interviewed about 6 out of a sample of 1. I mean, not sample, it's full set.
It's a survey.
6 out of
No,
4.
census, sorry. Okay. Is there any final questions?
Regarding all the, like, from what I gathered from the discussion that we're having, discussion plays a large part because most of these questions involve morality as the principle, in the absence of any concrete criminological theory which is being concretely advised to all judges and to the judiciary as such. So, have there been any attempts by any legislature of any country to actually come across a coherent criminological theory which justifies the need and the object of punishment and why it should be implemented? And is there any progress with respect to that?
A lot of countries have sentencing guidelines, and sentencing guidelines are based on a theory of punishment. So when you're drafting guidelines, you sort of decide on a particular theory or theories, and then look at how you would go about punishing a person. We don't have that in India, and I'm not sure whether that's a good path to be actually taking. The one thing that we had was there is a plain case doctrine in the particular death penalty, which was an attempt to a disaster of an attempt to try and do something like that. So something that I mentioned in my presentation is in context of mitigating factors, right? So if you take young age as a mitigating factor in one case and take young age as an aggravating factor in another case, it's very clear that you're using different theories of punishment for the same factor that you're taking. So one way I think UK has done that in its sentencing guidelines is to say for a particular crime you use a particular theory, and then we'll decide on what factors are relevant and irrelevant. But there's not enough, I think, research work in India to actually get to that point. We've not done enough work to say that we should be going to that. Though law reform in India has suggested that, or committee reports have suggested that, but I don't think we are at that position in India right now.
Whether it is coherent as well. The problem is, like, I did come across some examples, but the examples were, they contradicted themselves. You had deterrent theory juxtaposed with other theories, such as, for example, the retributive theory at the same time, and most of these.
When you say examples, what examples?
Justice Act, I think, in the United Kingdom.
The Criminal Justice Act in 2003 in the United Kingdom helpfully manages to have every penal theory.
Section 42 of Criminal Justice Act 2003 has conflicting 5 factors, 6 factors, and all of them seem to be cutting across each other.
Yes, I think the one thing is you cannot have one theory of punishment governing your entire criminal law or all your crimes, and that's my opinion. So if you take a particular
discretion to the judge, and judge has got to act according to his conscience, and that is what is expected.
And the exercise of discretion should be within the framework of the law, within the constitutional framework. If you're in exercising your discretion, you're going out of that framework, then that's an abuse of discretion, which means it's not an exercise of discretion at all. That's why there are, of course, there are various in the US federal sentencing guidelines also use all theories of punishment. So it's not as if they are providing any sort of guidance to that matter. But for instance, if you look at the sentencing guidelines in the state of Minnesota, that use just deserts as a theory to construct the entire sentencing grid. So there are countries and states which have done that. And so there are different approaches that everyone takes. So in India, a one-size-fits-all will not work in a place in a country like India. for all offences and across every state, like Anup is saying, each state might have a different way of dealing with punishment, which is why we should be careful before we transplant someone.
On that note, yes. We are full for the day. Well, thank you very much. Before we close, we should thank our speakers once again. Thank you everyone for participating.
Thank you,
Thank you.
and